Hi, I'm Natalie Wood, Associate Solicitor in Boys Turner's employment team. This employment podcast series looks at the different elements of corporate support work that we do as employment lawyers. In this series so far, we've looked at different types of corporate acquisitions and the typical process involved with buying and selling a business and the different aspects of each. We've discussed the operation of TUPE and how this can add a layer of complexity when dealing with asset sales. If you've missed any of these episodes, just have a look on our podcast channel or see the links in the show notes. In this episode, we're going to be discussing possibly the most important aspect of buying a business, and that's the due diligence process and what we as employment lawyers look at as part of that process. We're going to give useful hints and tips for both buyers and sellers to make sure that the process runs as smoothly as possible. I've been having a chat with Katie Harris, who is a senior associate in our employment team, and started by asking her, what is due diligence, or as we call it, DD, and why do we do it?
Fundamentally, whether you're dealing with either a sale or an asset purchase, the same principle applies, and that's caveat emptor or buyer beware. It may come as a surprise, but actually there is no legal obligation on a seller of a business to disclose any defects or liabilities in that business. So it really is up to the buyer to conduct its own investigations. There is one small exception to that, and that's where, if we're dealing with an asset purchase and TUPE applies, there is a specific legal obligation on the seller to disclose a set of information about the employees who are transferring as part of that business called employee liability information. But otherwise, it's very much on the buyer to, conduct their own investigation and satisfy themselves that they know what they're buying. It's a bit like buying a house. You wouldn't want to buy a house without conducting a survey on it. You want to know what you're getting, warts and all. And you also want to make sure that you're paying a fair price for that house. If it turns out that the house needs, 10 or 20 grand's worth of work on it, you might want to try and knock that off the purchase price, or you might decide not to buy it at all. It's exactly the same when buying a business.
And so then from a buyer's perspective, would you say it's fair to say the DD process is kind of more of a risk management kind of activity?
Absolutely, yeah. It's identifying areas of potential risk and liability, and then putting in place measures where possible to mitigate, minimise, or remove that risk and liability.
And sort of in terms of measures, what kind of things do we mean by that?
So typically what we mean here is looking at addressing that risk and liability through the terms of any sales or purchase agreement. And the sort of terms we're talking about here are warranties and indemnities. And these are legal mechanisms that help to apportion the risk. That's the main thing that we do, is we'll look at addressing risk through the terms of the agreement. Other things that we can do is we might ask the seller to rectify a problem before we complete. But if the potential financial exposure or risk is particularly high, it can involve potentially renegotiating the purchase price, or in extreme cases the buyer might decide not to proceed with the purchase at all.
I see. And the seller's perspective in respect to the DD process, I presume is largely responding to the buyer's requests for information and is more reactive, I suppose, except for in the TUPE situation that we spoke about before, where they have to provide that ELI information.
Yeah, that's right. So, typically the DD process is driven by the buyer. There are some very limited cases where a seller might actually want to control the DD process. Typically, we see that in the case of a sale by auction, so where a business is being auctioned off. But generally speaking, it is the buyer that will drive the process for obvious reasons, because it's the buyer that wants to understand what the potential risks are in the business it's buying. But having said that, sellers do still have an interest in wanting to make sure that sale goes ahead. So it is uncommon to find a seller that is uncooperative. And then the other thing that sellers also need to bear in mind is that they will be asked to give warranties as part of the purchase agreement. And a warranty is a promise that a certain set of facts or situation is true and correct. And, by disclosing information, they can actually limit their potential exposure under any warranties that they may be required to give. And again, this is a bit of a complex area that we will go on and talk about a bit later. But fundamentally, it's in the seller's interest to be cooperative and to provide as much information about that business as it can.
Because ultimately they want the sale to go through as well.
Exactly that. Yeah.
Now, how far and wide then does the DD process span?
So as you can imagine, we're looking at a very wide area. Due diligence process looks at all aspects of that business. And so we'll typically look at things from, what property is owned through to the commercial contracts that are in place and whether there are adequate protections for intellectual property, for instance, how the company conducts its business, does it comply with all relevant regulations? Is there tax compliance? What's its financial management like? So as a result of that, the DD process is very much a team effort. It involves a collaboration between, often a large number of different specialists. Legally, that would typically be commercial lawyers, corporate lawyers, property lawyers, employment lawyers, who will work as a team together with accountants and tax specialists. The team is normally headed up by the corporate lawyers who will project manage the process and generally act as a single point of contact for the client. But it's very much a collaborative team effort.
So DD, how integral is it in terms of the employment side to a transaction?
So employment due diligence is extremely important for a number of reasons. First and foremost, I think for most businesses, employees are integral and fundamental to that business. For some particular types of business, the entire value of that business is the employees themselves. So particularly in those cases, the buyer will obviously want to make sure that those employees, which is where the value is, are going to form part of that purchase. They're not going to go anywhere, but we'll also want to understand, or make sure the business is protected if they were to leave, and we'll want to understand the costs and potential liabilities involved with those employees. And the workforce is a substantial cost to any business. So a buyer will want to have a really good picture of what that cost is as part of the process. And then another thing to bear in mind is that employment law is a very complex, fast-moving area of law, and as a result, it inherently poses potentially significant risks to a business. Employment claims are very costly to deal with, and if a business has a lack of compliance with employment legislation, that can lead to substantial liability. So particularly in relation to pensions compliance, right to work checks, national minimum wage,
and holiday pay as well.
Exactly. If there's a lack of compliance with those things sitting within that business, then there's potentially a substantial liability there that the buyer might be inheriting.
In terms of the practical side of DD, so obviously, the DD process itself is hugely important, but how does it work? What's the starting point?
So the starting point with DD is normally, a questionnaire. And the questionnaire is normally prepared by the buyer's advisors and will be sent to the advisors acting for the seller. And that will contain a list of questions covering all those different areas that we just talked about. So questions about the corporate structure, about the commercial side of the business, so the clients, business contacts, suppliers, and from our perspective, questions about the employees as well. Normally, it will be a sort of fairly standard set of questions, but it is often tailored depending on the particular transaction that we might be working on at that time.
And what would you say is the key purpose of a DD questionnaire?
So it's all of the things that we've just talked about, really. So the questions from an employment perspective will be designed to elicit details of all the employees, workers, but also other individuals, so self-employed consultants, for instance, who are engaged within that business. So we'll be looking at details relating to their start dates, basic terms of employment, We'll be asking for copies of relevant employment contracts and policies, and also trying to elicit information so that we can identify areas of potential risk. So we'd be looking at, whether there were any recent terminations, are there any current or anticipated claims or grievances or disciplinary proceedings? Are there any employees on long-term sick, for example?
I mean, working on sort of these transactions, I mean, it is fair to say that our focus areas change from transaction to transaction. Could you just give a bit of detail around sort of how and why they vary?
Yeah, of course. I mean, obviously, there are fundamental things that will be the same across kind of all transactions, but it is really important from the outset as employment lawyers that we understand the particular objectives of that client and what their goals are with the business that they are acquiring. So examples might be if there are any employees who are particularly important to the business, we need to be aware of who they are so that we can, again, make sure that we're identifying any risks relating to them, and what plans that the buyer may have for the future of the business. So is there potentially going to be a cheaper transfer in the future, or redundancies, or change in job roles or contractual terms that we need to take into account, because that might mean that we need to obtain particular types of information as part of the due diligence process to help inform that sort of future strategy, or to identify the future risks that those actions may pose. The nature of the business is also something that we need to consider and bear in mind, and so we might adjust our focus on due diligence depending on particular risk areas of that industry. So an example would be, for instance, in the hospitality industry, issues with working time and national minimum wage can be a particular concern. So due diligence efforts may be focused on those particular areas. Likewise, in some industries, particularly IT, for instance, have historically had a very high usage of self-employed consultants and contractors, which could potentially pose substantial employment status risks. So again, we would, if we're acquiring a business in that sector, we might be particularly alive to that, the potential for those issues.
And presumably also sort of client needs and wants in sort of terms of the scale of the DD process and sort of weighing up with costs. Presumably that comes into it also.
Absolutely. Yeah. I mean, like a full due diligence process is extremely costly because it's very detailed and very thorough. And it's really important to make sure that that's proportionate to the value of the deal. And some clients, for those reasons, may want due diligence to be limited or focused only on specific areas, or, problems that are going to be real deal breakers potentially. As employment lawyers, it's so important that we are able to take a pragmatic and commercial approach to due diligence, because obviously everyone wants this transaction to go ahead. So, it's a careful management of sort of weighing and balancing the risk. And we can really only take that pragmatic and commercial approach by fully understanding the needs of the client and what they want to achieve.
That's all really interesting. How would you say a seller would respond to a DD questionnaire?
So once the sellers have received the questionnaire, they will normally provide a written response to those questions. And usually there will be associated documentation that needs to be disclosed to the buyers. So in an employment situation, that would normally be contracts of employment, policy documentation, pensions documentation, things like that. Now, back in the good old days, which sadly I'm old enough to remember, oh the shame, this used to be literally physical rooms, which would be piled full of boxes and boxes of paperwork, which would then need to be, trawled through with a fine-tooth comb by the lawyers acting for the buyers. But thankfully, times have moved on, and nowadays the use of virtual data rooms are widespread. And a virtual data room is essentially a hosted service. So it's sort of a secure online, in the cloud area where documentation can get uploaded electronically and can be accessed by, whoever needs to access it as part of the transaction. And these are really, such a great advancement because there are so many advantages to this. There's security, obviously, access to the data room can be monitored and restricted. You can get a clear view of what documents have been uploaded when, which is really helpful. You can have control over, what's going on with those documents. You can see who's accessed the data room and when, etc., and just helps to maintain confidentiality and really helps the acquisition to proceed much more smoothly, particularly as being virtual. The documents can be accessed anywhere at any time.
Which definitely helps.
Yeah, it really does. Much better than the days of the big room and the box files. Definitely.
Yeah. And so once those documents have all been uploaded to our data room, what happens then?
So, in simple terms, what happens then is that the lawyers acting for the buyers will review all of the information and documentation and decide if any further information is needed, which is pretty common. Usually, sometimes not all questions have been answered. Sometimes the questions are, misleading or unclear. And so we need to go back and ask further clarification questions, which can take quite a bit of time.
Yeah, and something we sort of tend to see quite a lot with things like pensions, for example.
Yes.
Yeah.
Yeah, it's absolutely. It's very common and can be frustrating, particularly for the buyers, because having to go back and raise further questions obviously takes additional time, which means additional money. And when everyone's sort of obviously trying to work towards a deal time frame, it can be quite challenging.
So what challenges do you often face for the DD process when acting for a buyer?
So, yeah, I mean, as we've just said, incorrect and misleading information being provided to us by the sellers is a frequent one. An example was where we had a transaction recently where we asked, as we always do, for the continuous start dates for employees, which is obviously, important piece of information because that sort of determines what employment rights they have, for instance, unfair dismissal and redundancy. So it's a key piece of information that we need to know in order to be able to advise on risk. The dates given to us by the sellers were incorrect. They were actually the dates on which those employees had cheaped across from an earlier transfer, rather than the dates on which their continuous employment began. And this was a large number of employees. And unfortunately, that issue wasn't immediately obvious to us. And it was something that only emerged as we were sort of fairly far down the process. So that was frustrating because it then meant that once we had got the correct information, we had to review and revise our advice to the client. So that creates a lot of additional time, which can be quite difficult, and it can impact our ability to be able to give clear, timely advice to a client. So that's a problem.
Yeah, and presumably it can impact the deal timeline as well.
Yes, it will. Absolutely, yeah. If we're not getting clear information when we need it, then it can be problematic.
So in terms of reoccurring themes, what would you say are the top 3 or 4?
Reoccurring themes in terms of due diligence issues that we notice. Yeah.
Yeah.
Gosh, that's a toughie. Okay, well, I think number 1 would have to be issues with holiday pay. Holiday pay, as I'm sure many people listening will know, is a horribly complicated area of law, and many companies we find just still haven't quite tackled how to deal with the requirement to include bonus, commission and overtime into holiday pay calculations. So through due diligence, we often find that this either hasn't been done properly or it hasn't been done at all. And this seems to be a common reoccurring theme regardless of the size or sophistication of the client. And in fact, oftentimes we find the larger the client, the more significant the issue. And holiday pay claims can be a ticking time bomb. Just because an employee hasn't or no employee's raised anything so far doesn't mean they won't. And frankly, it only takes one to cause an issue. So, and if holiday pay hasn't been calculated correctly, then that's a a potential liability going back 2 years for each employee. So it can be substantial and would be a real concern to a buyer. The second issue, which we see frequently, is self-employed consultants. Most companies, are really familiar with IR35 obligations and the steps that they need to take when they have contractors who are operating through their own limited companies. But what we come across in almost every single acquisition is, at least one or two self-employed individuals engaged by the business whose employment status hasn't really been properly considered or looked at. And, this can be a real problem, because if in fact, those individuals are engaged as employees or workers and aren't genuinely self-employed, then this could cause substantial issues. So tax liability going back 6 years, failure to pay income tax and national insurance, potentially holiday pay and pensions claims, which can also, in the case of self-employed contractors, can also potentially go back 6 years rather than just
fairly substantial.
A big issue. Yeah. And in some cases, I mean, we've worked on acquisitions where there hasn't just been one or two individuals engaged on this basis, but hundreds. And so you can imagine there, from a buyer looking at inheriting that potential liability, it's really difficult. Thirdly, and this might come as a bit of a surprise, I think we find pensions auto-enrollment can be a bit tricky. Yeah. I mean, it's a strange one, because most businesses, everyone knows that we need to auto-enroll employees into a pension scheme. And, every business, I don't think we've come across a business that hasn't got a qualifying pension scheme with employees auto-enrolled into it. And often employers are really good at making sure they've done their declaration of compliance, and everything is kind of on paper looks great. But where we often see the issues is with employees just not being enrolled in time. So employees have to be enrolled into a pension within 3 months from their employment start date. And frequently we come across companies where, in some cases, employees have been enrolled months, or in some cases years after they should have been, without any real explanation as to why. And of course, that could potentially be a liability for missed pension contributions. Failure to keep opt-out letters is another one that we commonly come across. And then I think finally, because you asked for sort of 3 or 4, I've got 4. I've got 4. The final one is, got on my soapbox now, right to work checks is another one that we see frequently. It seems to be a really misunderstood area, and I'm not sure why this is the case, but again, employers are really good. They know that they need to check if employees have the right to work in the UK, but what they're not so good at, we find, and again crops up as a common issue in due diligence, is keeping a record to show that they have conducted those checks properly, and that they conducted them before employees started work.
And often too, that they've actually checked the right documentation. So, a driver's license isn't sufficient, for example.
Yeah. And the issue that you've got, if it's not done properly, it's not something that you can retrospectively fix either. And, and again, it only takes one of those employees to not have the right to work in the UK, or be illegally working, or to have provided forged documentation. And there's potentially a significant and potentially criminal liability there, which a buyer will really not be very happy with. So those are kind of our top 4 kind of due diligence problems that crop up regularly, I would say.
So what areas are of most importance or concern for buyers in this part of the process?
So again, I mean, it depends on the buyer and their particular the industry sector and things like that. But obviously, I think it goes without saying that buyers will be mostly concerned with anything that we find that could be a significant liability. Having said that, obviously they want to be pragmatic and proportionate. So it's all a question of balancing risk. For example, a buyer is going to be less concerned about a failure to comply with, Section 1 of the Employment Rights Act, which is a minor compliance issue, than they would be, if they've discovered that they've got hundreds of self-employed individuals who have never had their employment status assessed properly, and potentially have 6 years of tax and holiday pay liability. It's a question of degree. We find that when acting for buyers, that obviously, to help them make decisions, it's really important we're able to give them a clear and as accurate as possible view of the level and extent of financial exposure and risk. If financial exposure is fairly limited or the risk of liability occurring is quite low, then the buyer might be, quite happy to rely on specific warranties in the purchase agreement, or simply just to take the risk. Clients just aren't interested in the details or legal nuances, understandably so. They're working to tight timescales and under commercial pressure. They just simply want clear advice on what the issue is, how significant it is, and they want us to provide a commercial solution. So, again, just going back to what we've already said, in order to do that, it's, you need knowledge and understanding of the business and the client that you're acting for. But also being very quick and responsive is also appreciated, given how fast moving and time pressured these transactions can be.
And so taking sort of the DD process, once we've got all the information and responses from the sellers, what is the next stage in the process?
So once we're happy that we've got all the information that we're going to get, and we've seen all the documentation that we need to see, we then compile what we call a due diligence report, where we would set out and analyse what's in the business and identify and flag areas of potential risk and liability. We use what we call a red flag report. So, red being the most significant issues that really need to be addressed before completion. Orange are things that, buyer needs to think about, may want to take some action, and green is obviously all happy and good to go. The DD report will get sent to the client, and that really forms the basis for them being able to give us further instructions about issues that they're particularly concerned about, that we can then use to inform whether further clauses need to be put in the purchase agreement to address any particular issues. So, for instance, indemnities or warranties to address risks that we've identified. And I think what I would say is, while this all sounds like a pretty clear process, so we have our initial questionnaire, we make further inquiries, we get the replies, we produce a DD report, I think the reality of the situation is that all of these things tend to happen in conjunction with one another. Due diligence is a process that continues almost right up to completion, because things change. Business is a moving beast. It doesn't just stay static. It will continue to function and operate the whole time. And so because of that, things change and new information can come to light, particularly with employees, because, we frequently find that employees might leave, new employees might join, some employees might get a pay rise, another employee might have done something naughty and be on a disciplinary. And this all changes, right up until the end, really. So we're constantly having to review and update the due diligence and the report and our advice to the client.
And when it comes to drafting indemnities and warranties, negotiating on those, quite often that can elicit more disclosure because the seller doesn't want to give a certain warranty or agree a certain indemnity or wants to limit it.
Yes, absolutely.
Yeah. So, two-pronged question. What tips can you give to buyers and sellers? So I guess maybe starting with sellers. What tips would you give?
So I think biggest tip I can give to sellers is to just make sure all your ducks are in a row before you start the process. For all the reasons we've talked about, so check your employee records. Have you got everything? Is the information accurate? Try and anticipate what the buyer will be asking for, and just make sure it's there and ready to go. Have you done your right to work checks? Have you got the documentation to show that you've done them? Have you got your pensions information to hand? When dealing with employee details, we find it's really useful to work from a spreadsheet that contain all the core details of each employee. So perhaps think about, doing that. And, if there is a compliance issue or liability, it's better to disclose this early on, but don't be drawn into providing lengthy responses or substantial information that's disproportionate to the risk. Obviously, there is a need to still try and be commercial and pragmatic.
And then advice to buyers.
Have a clear idea about what your concerns are from an employment perspective as early as you can. And, it's really important to clearly outline the scope of due diligence in order to make sure that costs are manageable. So, for instance, do you want to know about all liabilities and risks or only those over a certain value? Do you want to know about all of the terms of all the employees, or, are there any key executives or particular group of employees that you're worried about? Are there particular employment issues in your industry that you want the due diligence to focus on? Are you concerned about the potential for any claims to be raised, or are you only interested in knowing about actual or kind of known claims and liabilities?
So some great tips there for buyers and sellers, and also some really great insights. So thank you.
No problem. Thanks, Natalie.
That was Katie Harris, Senior Associate in the Employment Team. In our next episode, we'll be discussing pension issues that can often crop up in corporate acquisitions. These can be tricky areas, and we'll be looking at the risks that arise and key things to look out for. Just subscribe or follow the podcast and you'll be able to listen to the episode as soon as it is available. Thanks and goodbye.